I had to run through a few alternate titles for this video, including The Blake Lively Case Made Me Remember Why People Hate Lawyers, Baldoni versus Lively, a masterclass in lawyering and why that's the problem, Why Are Lawyers So Unlikable, Blake Lively, Justin Baldoni and the Legal System Under Fire. I also started thinking about quotes about lawyers that are almost always negative. The first thing we do, let's kill all the lawyers. A lawyer with his briefcase can steal more than 100 men with guns. Lawyers are the only persons in whom ignorance of the law is not punished. The J.P. Morgan classic. I don't want a lawyer to tell me what I cannot do. I hire him to tell me how to do what I want to do. A good lawyer knows the law. A great lawyer knows the judge. 99% of lawyers give the rest a bad name. Lawyers, the only people who write a 10,000-word document and call it a brief. So that leads me into today's topic. Why are lawyers so unlikable? And before you bristle, let me say I'm not an outsider throwing stones. I used to be a lawyer, and I still am, kind of, sort of. Like a lot of the topics I've chosen to talk about lately, this one was triggered by the Blake Lively Justin Baldoni case. In that matter, we saw something quite unusual. We had millions of ordinary people, not lawyers, reading legal documents, watching legal commentary, and engaging deeply with the mechanics of the legal system. Although the profession of law has always been highly criticised and spoken about in pejorative terms, it's normally in the general, and suddenly, with this case, I've seen that the legal profession has found itself under a microscope. Scrutiny has been put upon not just the parties to the case, but the lawyers as well. Legal commentators who were originally outlining the case and explaining procedural tactics, dissecting filings line by line, are suddenly being called upon to defend what are, from a lawyer's perspective, entirely normal, strategic, business as usual actions and tactics. The thing is, these decisions and actions look very different to what I call normal people, people who aren't wearing lawyer goggles. And I found it very interesting that I've seen that this makes a lot of lawyers quite uncomfortable because even though they're used to speaking to the public and talking about issues and explaining things, I'm not sure they're as used to being under fire and scrutinized by the general public for lawyering itself, what we as lawyers do and why we do it. So the reason the Baldoni Lively case has been so fascinating for me is that not only has it exposed some of the weaknesses and biases in mainstream media coverage, it has also shone a light on specific actions of the legal profession itself. Not just about lawyers, but how do lawyers operate? Who do we serve? How much of the process that we follow is accessible, let alone understandable, to ordinary people? Like I said, I'm not just an outsider throwing stones. I used to be a lawyer, and even though I've left the practice of formal law, I still do a lot of legal adjacent work. Being a lawyer isn't something that you just give up, especially when it's been such a big part of your life. And this case has certainly made me think a lot of thoughts, and that's with an uppercase T. I think one thing that most lawyers know but never want to really acknowledge is that we live in the grey. We operate within a space of ambiguity. That's our job. If the law was always crystal clear, we wouldn't be needed. So it's not clear, and we are needed. And the question isn't always what's right or moral. It's what's legal or legally possible. The tension between morality and legality can certainly wear you down over time, and I certainly found it quite exhausting. Sometimes the strategies employed by lawyers aren't wrong in the technical sense. They're legal, but they feel off. They feel morally ick because they exploit grey areas. They game the system. This is not because lawyers are bad people, but that's because that's how the system was built. It was made by humans. It is fallible. It has loopholes. And when you are representing and advocating for your client, you use those loopholes. There's something very symbolic about the phrase the devil's advocate. It was literally originated from the Catholic Church, someone who is appointed to argue about canonizing a saint. Over time, it has become synonymous with lawyers, people who will argue any side, even the unpopular one. In popular culture, it's almost literal. Lawyers are frequently cast as people who would defend the devil himself or herself. And here's the thing. Everyone hates the devil's advocate. In normal life, when you're sad and upset and stressed, and you look to a friend and you vent to a loved one, you are not asking for legal opposition. You are asking for support. So lawyers often fail that emotional test. We argue, we question, we say, let's look at this from the other side. We detach from emotion and we pride ourselves on objectivity, when what the other person wanted was empathy. So although this is professionally sound and appropriate, from a personal perspective and a normal person's perspective, it's incredibly annoying. There's another distinction that's worth drawing, and that pop culture tends to blur. A lot of the public perception around lawyers, especially the moral outrage, is usually directed at criminal lawyers. That's what people picture when they think of courtroom drama, or someone getting off on a technicality. Most lawyers, especially in big corporate firms, aren't in courtrooms. They're in boardrooms, in spreadsheets, in deals, sending a lot of emails. The emotional reaction still sticks. There's also a proverb floating out there that says, if you lie down with dogs, you'll get up with fleas. And that's exactly how a lot of people view lawyers. They look at us and they think, if you spend all of your time representing morally dubious people, what does that say about you? There are also lawyers whose loyalty can be bought. There's the perception that money can buy you not just legal services, but moral coverage. It's a very corrosive perception, and it feeds the worst stereotypes about the profession. We also have the term ambulance chaser. This is a nasty one, used originally to describe personal injury lawyers who are accused of exploiting tragedy for profit. The phrase conjures up images of a lawyer literally chasing an ambulance to get to a potential client first. Over time, the term has expanded. These days, you see these so-called ambulance chasers circling like vultures around any form of public tragedy, whether it's a car accident, a corporate scandal, a natural disaster, or an environmental crisis. If someone's child is injured, if there's a deadly flood, if there's an industrial explosion, you'll see law firms advertising, recruiting plaintiffs or filing class actions against someone who can take responsibility and someone who can pay. It's not that there's no merit to these cases. Many of them are completely valid, but it's the optics that sting. In the same way that it feels distasteful when someone shows up to a natural disaster to sell bottled water, it can look and feel equally gross to have lawyers show up to capitalise on grief, trauma and outrage. There's often an emotional need in the wake of a tragedy to find someone to blame, someone to sue. For some lawyers, that's not a deterrent, it's a business model. So fair or not, this does reinforce the image of lawyers as people who feed off pain. The public sees this, they remember it, and they resent it. A very recent example that did trigger this video for me was the Blake Lively and the cleverness move. I'm not going to go into detail with the legal mechanics because that's not really what I'm here for. I just wanted to let you know kind of what started this process in my mind about thinking about this issue. Her law firm used a subpoena process in a way that was arguably technically legal, and again, arguably unethical and potentially immoral. In essence, they used a subpoena process and a lawsuit against unnamed does to obtain access to information to which they might not otherwise have access, in a way that did not require them to provide notice to people about whom that information related. There's been a lot of debate about this and toing and froing about whether it's right or not. I'm not going to dive into that. What interested me wasn't the tactic itself. It was the reaction from lawyers online who praised it as clever lawyering, and the fact that when they were criticised by members of the public for praising that lawyering, they got quite defensive. So in their mind, it was legal, you're allowed to do it, and it was considered to be good, aggressive, strategic lawyering. And they considered that to be appropriate when advocating for their client. And this is absolutely true. That's true. They even almost admired it, saying they hadn't thought of it, kind of wish they had. This is a very common trait amongst lawyers because you really there are definitely lawyers who get off on the cleverness of it. It's a game for them. They love pushing the envelope. They love sailing to the edge of the, what's possible. And it's a really sad and boring form of legal thrill seeking. So I do get that, even though it's not something I personally enjoy and I've never really admired myself. The thing is, when I saw the call out, I did think it was interesting that the same lawyers that say you need to look at both sides of the argument, you need to be able to be devil's advocate, blah, 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 all that kind of stuff, they got quite offended. And they couldn't quite understand why a normal person would be so aggrieved by what they had just seen here. And for me, it's because we as lawyers, we forget how privileged this kind of cleverness is, that only clients with deep pockets and elite representation can even play this high stakes game, let alone win it. So when you see lawyers out there applauding tactics like this, from an optics perspective, it is reinforcing why people, ordinary people, distrust lawyers. Lawyers then look like smug insiders in a rigged system, which only has access to those with deep pockets. I go through this a little bit more when I discuss snobbery further on in the video, and I also address it more specifically in the postscript to this video. In terms of the negative perceptions of lawyers, this can vary depending on the sort of law you're in, but ultimately, I think there are negative connotations regardless. But I'm just going to go through them quickly. Criminal law, this is high stakes, emotionally charged. Lawyers are seen as either heroic defenders or slimy enablers. Family law, deeply personal, often brutal, it's rarely clean. Tax law, perceived as frequently seen as only being about helping the wealthy minimise tax. Some call it tax evasion. These days, the politically correct term is tax minimisation or optimisation of income. Corporate and commercial law, which is my background, this is seemingly neutral, but even here, I sometimes struggled when having to push positions I didn't believe in just because that's what the client wanted. It's less morally challenging, but it can still be annoying. Litigation. This is adversarial by nature. It's about disputes, civil, commercial, personal. It's a zero-sum game. Someone wins, someone loses, and the lawyers walk away paid regardless. Finance law. I appreciate other people may have a different assessment of this, but a lot of finance lawyers in big firms spend a lot of their days helping already wealthy clients stay that way or get wealthier. I think that's the model. Mergers and acquisitions, which is facilitating buyouts and deals either publicly or in a private context. These are big wins for business, but there's frequently pressure to make the numbers look right, and these are frequently kind of like selling a used car or a house. There are a lot of facts that are dressed up in certain ways so that you can make a sale. Environmental law. This should be good, right? Because it's noble. We're protecting the environment. But sometimes it's controversial, especially when it's being used to protect corporations from liability. What about employment law? Surely that's always good because that's a lifeline for wronged employees. Well, it can also be used by large corporates to minimize the protections and rights that employees might have, and it's to minimize the liability of an organization. Then you have competition or antitrust law. In Australia, we call it competition law. In the US, it's called antitrust. It is used to hold corporations accountable, but the lawyers that practice in this area in the corporate sector frequently are called upon to figure out how to engage in monopolistic, anti-competitive behavior that stays within the bounds of legality. So these lawyers often walk a very fine line, advising clients on how to technically comply with the law while still maintaining market dominance. So, it will relate to areas like price fixing, conferring with competitors, which they're not supposed to do, and that sort of thing. And generally, when you look at the area of law which relates to compliance law, like the lawyers that are there to advise their clients on how to comply with their regulatory and legal obligations, this looks really good on paper because it's ensuring that they follow the law. But it sometimes also means advising on the bare minimum of what's required to avoid trouble. It's not always about how can you be the model corporate citizen. It's frequently what's the least that can be done without getting sued or fined. While there are many lawyers who are really trying to focus on best practice and ethical governance, that's not always the dominant approach because that's not always what the client wants. Now, of course, I have to mention the lawyers on the other side, the legal aid lawyers, the public defenders who represent people who often can't afford legal help. These are the ones fighting for the underrepresented, the vulnerable, the marginalised, and they are essential for access to justice and legal representation. But the uncomfortable truth is that many of these lawyers are underpaid and overworked. Often, although not always, they may be less experienced or have fewer resources than those working at top-tier firms. It's not about talent, it's about systemic disparities. There are certainly brilliant, highly principled lawyers who choose to work in these sectors, and they sometimes turn down massive salaries to do what they believe in, but that is unfortunately the exception, not the rule. So we do end up with a system where the quality of your representation can frequently correlate more with your income rather than your moral right to access to legal representation. So the next thing that I wanted to flag that I've noticed while watching all of the legal commentary on the lively Baldoni case is that it reminded me about snobbery in the profession. Lawyers are often very well educated, highly trained, articulate people, and they're very aware of it. Lawyers speak their own language. We create barriers, whether intentionally or not. Legalese isn't just precise, it's exclusionary. I didn't realize this until I started working with a lot of engineers and non-lawyers, and suddenly I was the novice. It was extremely humbling. When I worked with technical people, I couldn't understand their language. When I started working with non-lawyers, I realized I really had to explain everything in a way that could be understood by people who hadn't been steeped in all of this legal jargon. Private practice reinforces this kind of snobbery. When I was in private practice, especially when we were doing, business development and, client management, we frequently heard things like, sometimes we understand the issues better than the client does, or you need to, help your client ask the right questions, or the client's not asking the right questions. You need to guide them so that, they go to the right place. Private firms frequently don't appreciate that the internal teams have more of the context. They know more of the moving parts. They know the things that can't be written down on a piece of paper. They can't. There are certain things you can't put in an email to brief your external lawyers, which you can verbally tell your internal team. When I was doing in-house roles, I frequently had to negotiate with my external lawyers to keep them up to date throughout a project. But that was on the condition that they didn't charge me in 6-minute increments, because I needed them to know everything that was happening on the project so that when I needed them, they could snap into action immediately without having to be back briefed on everything. But the downside of that is if you get charged for all of that, you'll go bankrupt. So that's the arrangement that I reached with them, and it worked quite well, but it really highlighted to me how dependent the external lawyers are on getting up-to-date information, which is not always possible. And then the snobbery exists even for in-house lawyers, because frequently in-house lawyers look down on non-lawyers. When we get requests for information and for advice from non-lawyers, there can be a lot of eye-rolling. There can be a lot of disparaging comments about bush lawyers or about annoying people who are asking dumb questions. I see that kind of snobbery a lot from a private practice perspective and also in-house. The next issue is the funeral home problem, which I did flag above when I was talking about lawyers being seen to capitalise from times of difficulty and grief. Lawyers can be a little bit like funeral homes. We show up during the worst moments in a person's life, and a person here is either a human biological person or a corporate person like a company. You can't avoid us. In the same way you can't really avoid a funeral director and you can't avoid a lawyer. There's a divorce, a death, a business collapse, an insolvency, a criminal charge. And the worst thing is, we get paid for it. So there's a perception that lawyers profit off grief and misery. And honestly, sometimes it's not wrong. Why do you think that there's a term, the only ones who win are the lawyers? That's thrown around everywhere. When there's a dispute, two parties fight. Even when there are cost recovery mechanisms in place, you never get back everything you want, and the only people who really do win and walk away with money in their pockets are the lawyers. So lawyers can be seen as helpers in times of crisis, but we are frequently seen as opportunists. In terms of why I chose to leave the law, I will do a separate video about that because there's a whole bunch of different reasons. One of them certainly was this sort of exhaustion about operating in the grey zone and not really getting off on the thrill of operating in the grey zone like some people did, because every time I did something, I was always asking myself, yes, this is legally okay, but do I feel all right with this as a human being? And if you ask yourself that question every day, it gets really exhausting. So even when you're acting ethically, lawyers work in a space that's defined by ambiguity and, finding loopholes. This does not make all lawyers bad, but it does explain the reputation. And for me, it certainly motivated me to not really want to be in a purely legal role anymore. So here's my postscript. I definitely don't want this video to come across as a blanket condemnation of all lawyers. There are plenty of good lawyers out there, people who entered the profession because they believe in justice, in advocacy, in giving voice to the vulnerable, in making sure that they're able to sort of do things impartially, play devil's advocate. Many of those people still hold on to those ideals even when the system makes it hard to do so. The media with its distortion doesn't help because the legal dramas we watch like Suits, Better Call Saul, The Good Wife thrive on extremes. Corruption, double dealing, last-minute courtroom stunts. They rarely show an average lawyer who's working really hard to do the right thing by their client. Most lawyers I know personally genuinely try to follow the rules of professional conduct. They take ethics seriously. They navigate impossible client demands, relentless time pressures, and massive responsibility with very little thanks. They're also pressured into doing things they probably may not feel comfortable doing. They make sure it's right, but they may not feel comfortable doing. So that's kind of one of the reasons why I left. This episode was never meant to dismiss good lawyering and good lawyers. It is simply my truth and my attempt to make sense of the public reputation that clings to this profession like a barnacle, sometimes unfairly, sometimes with reason. It's really not easy being a lawyer. I mean, lawyers are often treated as an insurance policy. Your client will be friendly when things are going well, but when things hit the fan, it's the lawyers who get thrown under the bus. They'll say, we were following legal advice. They'll say that as if legal advice is a shield that absolves them of all judgment, agency, or intent, and frequently they will sue the law firm. But in terms of what brought all of this into my mind today, it's in light of the Blake Lively, Justin Baldoni matter, that case didn't just attract legal commentary. It invited millions of ordinary people into a space that lawyers normally dominate. It dissected filings, questioned tactics, and evaluated conduct. And for me, something incredibly interesting happened because I have never seen so much interest in actual legal documents and the wording of legislation from normal people. Suddenly I saw the lawyers looking a bit defensive and uncomfortable because the scrutiny wasn't just on the legal case, but it was on the lawyers themselves and on the methods of lawyers and the ethics and whether or not it's defensible from a normal person's perspective. And I also started to think, well, I don't think it's a defense to say it's legal and therefore good lawyering. Because in the same way, a lawyer should be able to look at both sides of the conversation and play devil's advocate about an issue and whether or not you support the case, whether or not you support one party or the other. A lawyer should also be able to look critically at criticism that they are receiving for lawyering tactics and see it from the perspective of a normal person who normally doesn't play by those rules. A lot of major legal reform, whether it's tax, family law, privacy, corporate, competition, antitrust, happens because something was legal, but clearly not right. So, for instance, when the spotlight shines upon it, it reveals the loopholes. Public pressure builds. Lawmakers close the gaps. So when lawyers say this is legal lawyering, it is defensible, it is fine, it is normal, I think we also have to say, okay, that's fine, but should it be? Is this tactic in line with the intent of the law? Is this something we would defend if it was used against us? Is this right? And is this something that maybe should be changed by way of legislative amendment? So lawyers might be quick to critique others, media, influencers, institutions, but we definitely shouldn't shy away when the same spotlight turns upon us. Lawyers are not above questioning. We shouldn't be, because lawyers aren't the client. We're not society. We are only intermediaries. We're gatekeepers, advocates, people who are entrusted with giving people access to the legal remedies that they seek. If we can't explain what we're doing or why it's justified, then we deserve the pushback. So this is a really long way of saying the profession has its problems, but it also has people trying to do the right thing. And if you're a lawyer who's out there still doing work with integrity, good on you. You're the reason why I still believe in the law and I believe that it's important, even though I've chosen to not practice it myself anymore.